Good morning. Can everyone hear me okay? Wonderful. Morning, everyone. We'll get rolling in 2 minutes. Give some folks time to join. All right, we'll get rolling. Good morning, everyone. Good morning. Thanks for joining today's webinar. My name is David Goldfischer. I'm a senior counsel at Shapes Perlowitz Luftig. I run our firm's landlord tenant department. Also serve as a member of our transactional team. Some of you guys may have worked with us in the past. Just some quick background about our firm. We specialize in everything and anything related to New York City real estate. We have, of course, landlord tenant department, which is my domain. We also have a trust and estates team. We have commercial lending groups. So we have a very diverse and deep team at the firm here. We also do a lot of transactional work, of course, as well, which is really the bread and butter of our firm here. The topics of today's webinar are some of the recent law changes as it relates to co-ops, as well as the rental laws in New York City and sort of the latest and greatest in the rental market that we're seeing these days. As we go through this here today, feel free to interject with questions, comments, anything you want to discuss. If you have personal scenarios that may have come up and things you want to bounce off me, I'm happy to make this interactive. So let's get rolling here. The first topic I really want to talk about today is the new change in co-op law. It's not actually very well known these days in New York City. Most of you, I'm sure, were familiar with the rent law changes back in 2019, the HSTPA, Housing Stability and Tenant Protection Act, that really overhauled the rent laws in New York City. One of the major changes that were enacted back in June of 2019 was the cap on security deposits that landlords can collect. We all know that right now, as we sit here today, March 24th, 2022, the maximum amount of security deposit that a residential landlord can collect from a tenant is the equivalent of 1 month's rent. And that's across the board with free market rentals, be it a regular management company or an individual owner of a condo or co-op that owned the unit and is now choosing to sublet it or rent it out. Same rule applies, 1 month rent for security deposit. Now, when that law was enacted in 2019, incidentally, condos and co-ops fell under this law. Now, by way of background, the sort of spirit of the law was to create ease of access for renters. That was a term that many of the elected officials behind the Housing Stability and Tenant Protection Act kept on harping on, right? It was the ease of access. We wanted to provide more opportunities for people to rent apartments in New York City. It was becoming, the elected officials felt it was becoming burdensome. So they wanted to sort of ease this burden on potential tenants, which is why that cap on the deposit was enacted, right? We wanted to we wanted to help tenants out, help them get this apartment without having to lay out thousands of dollars up front in order to secure this lease. Now, one of the byproducts of this law, the way the bill was written, is that it applied to co-ops. Now, taking a step back for a second, we all know that co-ops, when you buy a co-op, you're not buying an actual, it's not real property, right? You're buying shares in a corporation, and you're creating a landlord-tenant relationship between yourself, meaning the owner of the shares, and the corporation. So what then happened after the new laws in 2019 were enacted was that incidentally, co-op owners were qualified as tenants and co-ops were landlords, right? Because as I mentioned, there is this landlord-tenant relationship, and they were bound by these laws. That meant that in the past, some co-ops had the practice of collecting a year's worth of maintenance in escrow at closing. They were no longer allowed to do this. Similarly, one of the other changes that were enacted was that there's a cap on late fees right now, right? So landlords are capped as to how much they can charge their tenants for late fees, and that cap is either the lesser amount of either $50 a month that they're late, or 5% of the monthly rate. So in most cases, it's going to be $50, but that's the cap. Again, it's the lesser amount of 5% of the monthly rent, or $50. So co-ops all of a sudden, starting in 2019, found themselves bound by this rule. Number one, they no longer can collect the escrow maintenance, right? Because like I mentioned, we're only capped at 1 month worth of deposit. And number two, you also are restricted on how much late fees you can charge, regardless of what was listed in the ground lease. Another couple of changes that were enacted in 2019 and had a profound impact on co-ops were some of the caps on fees as well, right? Right now, we all know that you can't charge more than $20 for application fees. But that applies to credit checks, background checks, et cetera, as well. So co-ops all of a sudden found themselves lumped into this rental category, which really, again, wasn't in the spirit of the law. So for the last, I guess it's going to be nearly 3 years in June now with these laws, but the last 2.5 years or so, many co-ops were grappling as to how to pivot, how to handle this. Finally, in December of last year, the Governor Hochul, signed into law, or I should say amended the Housing Stability and Tenant Protection Act to carve out an exception for co-ops. So all of a sudden now co-ops are now allowed to charge a year's worth of maintenance and hold that in escrow. Now, this plays a very big role, of course, in the transactional world. If any of you looking to purchase a co-op or represent a potential purchaser of a co-op, if they're sort of on the periphery with the board, maybe their financials aren't exactly what the board is looking for, this is sort of a unique tool you can offer up now to this co-op. You can say, hey, listen, I'll put up this year, maybe even 2 years if you want, of maintenance in escrow for you to hold. Now, just going off topic here for a second, if you do go that route and you do decide to put that year's worth of maintenance in escrow and the co-op accepts it, you can always go and try to renegotiate this after a year, become buddies with the president of the board, be friendly to the board members when you see them in the lobby, and say, hey, listen, after a year, assuming you've been an impeccable shareholder and a great tenant in the building, say, hey, maybe they can release that escrow. That's certainly a negotiating tool. But given that co-ops are no longer bound by these rental laws, you now have the opportunity to go ahead and put up however much maintenance in escrow that might sway the board. So it's certainly a very, very unique tool. Co-ops also are no longer required to give shareholders notice if they're increasing maintenance by 5% or more. This was another rule that was enacted back in 2019. There are certain notice requirements right now that are required for landlords if A, they are terminating their tenant's lease, or B, if they are raising their rent by 5% or more. Now, on that second aspect, the raising the rent point, that's actually become very prevalent these days, given the state of the rental market in New York City right now. The market right now, we all know, is on fire. The rent rates are through the roof, and many tenants who found themselves entering into leases either immediately before or even during COVID are now being faced with significant rent hikes on behalf of landlords. I'm getting multiple calls a day from tenants asking me if it's legal for their landlord to raise the rent by 10, 15, even 20%. Now, assuming we're talking about a free market unit, of course, a landlord can raise the rent at their discretion, provided, however, that they abide by the notice requirements. Again, these notice requirements are based on how long the tenant has been in the unit. So, for example, if the tenant has been in the unit for 1 year or less, and the landlord is seeking to raise the rent by 5% or more, 30 days notice is required. If they've been there between 1 and 2 years in the unit, 60 days notice is required. And if they've been in the unit for 2 years or more, then they have to submit 90 days notice to this tenant if they are raising the rent by 5% or more. So again, this is very, very relevant these days. If you're representing a landlord, or if you're a landlord yourself, make sure you're on top of this. Make sure that you you cross your T's, dot your I's if you are certainly looking to raise rent by 5% or more for an existing tenant. Now, co-ops, again, co-ops initially fell under this law. So if the co-op was raising the rent by the maintenance, by 5% or more, they had to abide by this notice requirement. However, they're no longer subject to this. So co-ops can raise the rent, maintenance, by 10% if they want overnight without giving any notice. Also, similarly, the $20 cap on background and credit checks no longer applies to co-ops. They can go ahead and charge whatever they deem appropriate. Late fees, they can charge up to 8% now. So the law was changed for co-ops from 5% to 8% of unpaid maintenance payments if they would like. And this is, again, very, very big victory for co-ops, managing agents, in that they are now no longer subject to these rules and regulations. Any questions on that before I head on to the next topic? And feel free if you want to chime in, unmute yourself, or knock something out in the chat box. Okay, so the next topic I want to touch on real quick is are the changes in SOHO NOHO and how they apply to artists in residence, AIR units. I'm not going to spend too much time on this because it's a very nuanced area of the law. And then if you want, if you have any specific questions you want to discuss with me, I'm happy to address them now, or you can hit me up offline. But we all know about the rezoning plan that took place at the end of last year in SOHO and NOHO. Now, one of the interesting things that took place as well is that we all know there's something called AIR, artists in residence, right? You have to qualify as an artist to live in certain loft buildings in this neighborhood. Now, the qualification of being an artist, it's a very, very high threshold, and it's very difficult for people to obtain it. Meaning, if you want to apply now, I think this city only gives out maybe 3 or 4 such certifications a year due to this high threshold. But many people that have it now have been grandfathered in since the 70s, and they have this certification. But in any event, one of the laws that was enacted, and there was a bill that was plumped into the whole rezoning package, was a penalty and fees provision for artists who would sell their unit to non-artists, as well as non-artists living in these units. Now, it's always been a very, not to say gray area, but an area that was never really enforced by the city, meaning non-artists living in these units. There was no one really checking up and following up to see if the person living in these units was actually an artist. However, there was a council member added a bill, which was actually later vetoed by the city, that would have subjected tenants to significant fines if they were found to have either selling their unit to a non-artist, or B, a non-artist living in these units. Now, the new mayor, Mayor Eric Adams, he vetoed this bill. Right, he came in and vetoed the bill. However, there's one important part of this that still remains. If you are living in one of these units and you want to convert this AIR unit to just a standard regular unit with a regular CO, you pay, it's essentially a flip tax of $100 per square foot. So, similarly to when you sell a co-op unit, many co-ops have something called a flip tax. It could either be a percentage of the purchase price, it could be couple dollars per share. However the co-op structures it, this is a similar idea here that apply to artists in residence units, meaning if they want to convert it to a non-AIR unit, they have to just pay that $100 per square foot flip tax. And again, this is something that it seems exorbitant, but it can be incorporated as a business term to the deal. The parties can negotiate how they want to handle it. Maybe they split it, maybe they share a portion of it. Lower the purchase price accordingly, things like that. It becomes another business term, the same way a flip tax is used on co-ops these days. So that's what's taking place in SOHO and NOHO at the moment. Any questions? Oh, Good. Okay. The last couple topics I want to touch upon is, sort of the state of the union right now, as far as the rental market goes in New York City. We're a little past 2 months since the eviction moratorium has lapsed and expired. There's a tremendous backlog right now, as we can all imagine, in the housing court concerning eviction processes that were not only started post the moratorium, but also those that were being held prior to COVID, which is a little over 2 years ago at this point, believe it or not. So you had this tremendous backlog of cases that were pending, plus the cases that were just started within the last couple of weeks. And things right now are obviously not moving too fast. So if you are advising a landlord, or if you are yourself a landlord, you're in a situation where you're working on an eviction proceeding, or you think you're going to have to commence an eviction proceeding, you certainly want to understand that this might be a long battle. Also due to the fact that the city has free legal aid now to tenants. So assuming a tenant wants to dig in and fight the eviction process, they can easily delay this for 8 months up to a year. So it's just something that you should keep in mind if you are unfortunately facing such a situation. It's not going to happen overnight, of course. Again, the backlog combined with just the general court process, even prior to COVID, an eviction proceeding in New York City can easily take up 6 to 8 months, and now it's you can almost double that. So it's going to really be a long battle, but that's not to say that you can't go ahead and commence these eviction cases. Again, there's no more moratorium, so you're free and clear to go ahead and start any legal cases you would like. On that note, now that there's no eviction moratorium anymore, the pro-tenant groups and many of the pro-tenant elected officials have now turned their attention towards something called the Good Cause Eviction Bill. This is sort of the new hot topic right now in the rental market. This bill, it's not a new bill. It's been in the state Senate for a couple of years already. It was introduced a couple of years back, and it's just waiting a vote on the Senate floor. Now, the pro-landlord advocates are very adamantly against this bill, of course. They call it universal rent control, and essentially serves as universal rent control, or will serve, I should say, if in fact it is enacted. What it would do is that it would give a tenant who's faced with a non-payment proceeding in court a defense. If they were faced with a rent hike that's 3% or more, they can raise this defense in court, and landlord would have to prove that this rent increase was justified. So again, the bill defines rent increase of 3% or more as unreasonable, and which is a little puzzling given that the state of the market right now, someone gets a 3% raise in rent, that's pretty low. They should be pretty happy. So 3% is pretty low. However, that's the threshold listed in the bill. Bill defines that as unreasonable. So if a tenant is faced with that increase and then they are in a position where they're not paying rent, and the landlord takes them to court for non-payment of rent, the onus will be on the landlord to justify that rent increase. So it's the threshold for commencing such cases, non-payment cases, and even evicting tenants is going to soar. It's going to become very difficult, and that's why landlords are essentially calling this universal rent control. They're fearful that if this bill is enacted, they will not be able to ever evict a tenant absent the tenant doing something totally egregious, meaning the threshold is going to narrow itself tremendously. So it's certainly something landlords, advocate groups have been pushing against, very hard. A couple of cities in the state have already enacted it. Albany, Rochester, I believe also, they've enacted a form of this good cause eviction bill as well. So this is certainly something you want to monitor over the next couple of months. It has the potential to really drastically alter the rent landscape, similarly to the way the Housing Stability and Tenant Protection Act did in 2019. So this is definitely the new topic in the rental market that's on the forefront of everyone's minds these days. We even had a couple of elected officials a number of elected officials have actually gone on record publicly to throw their weight behind it and say that they hope that the good cause eviction bill will in fact be voted upon and passed during the 2022 legislative session. So certainly something interesting to monitor over these next couple of weeks and months. Anyone have any questions or situations they want to discuss before we wrap it up? I'm going to post my contact info here in the chat box. If you have any questions, anything you want to discuss offline, please don't hesitate. Feel free to do so at any time. Oh, someone has a question. Alexandra, yes, I've unmuted you, I think.
Hold on, I'm on. Can you hear me now? Sorry.
Yep, I hear you.
Okay. I had a question about the security deposit rules and the prepayment of rent rules.
Yeah.
A couple of international clients who've run into this issue where they're well qualified or they're overqualified, or they have parents who are extremely well qualified, but they're international and they don't have US assets, or they just opened accounts, and they've been told basically that their only options are to pay for something like the guarantors or insurance or a third party that can guarantee their rents, or they can't have the apartment. And these third party companies can charge an exorbitant amount over. Like one of my clients got like 100%, like a 98%. Like he was like, it would cost like 98% of like what he's paying in rent. Like it almost doubled his rent, so he didn't want to go that route. Are there any thoughts around how we make it easier for international renters or people who don't have US social security numbers or something like that to rent in New York, whether it's like a legal vehicle, like some sort of easy trust that can be set up, putting assets here, or something along those lines?
Yes, that's a very good question. So obviously, this is the classic scenario, or the classic tenant, I should say, that's been impacted by the security deposit, right? The classic, foreign NYU student who comes to the U.S. to go to college, doesn't have any credit history, no social security. However, they're well funded, be it, their parents are willing to put up a year or two worth of rent, but the landlord can't accept it, right? That's a classic example. So there's been a number of, absent, of course, the situations you outlined with third-party companies, Insurant, Rhino, the guarantors. Absent using one of those companies, the only other solutions that we've seen, I had some clients that would take out a line of credit from their bank, have their bank issue a line of credit to the landlord, or letter of credit, I should say, which allowed, which at times will put a landlord to ease. I've seen that situation. We've also done situations, there's a bit more risk there, but we've also done situations where a tenant would put up a year's worth of rent, say in an attorney's escrow account, and that attorney would remit payment each month from the escrow account. The only, I guess, pitfall of going that route is that if there's a dispute between the landlord and tenant concerning the rent amount, I know, for example, like certain firms wouldn't want to be caught in the middle of that, right? You're an escrow agent, so you still have some duty here, and it could lead to an uncomfortable situation. But that is another unique option as well to navigate this cap.
Got it. Is there something that you guys, like if I reach out to you, if I have clients in that scenarios again, basically I had like a very like an adult client. He is like a very well-known international director, and he is just from not the US, and he's here for a project for a year, and it was a nightmare getting him a home because of all of these new rent laws. And he could have prepaid, he had the money in the bank, it was just in a bank in a different country, and that presented a whole bunch of other problems. So having a solution like that would be that, like an understanding what the fees are around that, just to make it easier for him, because it's been, we placed him, but it's been difficult for him to even like make rent payments sometimes, just because of getting the money in the way the landlord wants the money to them. Like they don't accept wire transfers, and we didn't know that until we signed leases. But if there's a way that, like, if I can just reach out to you if I have a client like that in the future.
Yeah, definitely reach out. 100%.
Okay. Amazing. Thank you.
Yep. Anyone else have any questions or anything they want to discuss? All right then. Well, thank you all for joining. Hope you found this interesting and insightful. Again, I posted my contact info there. If you need me, hit me up anytime. Call me, email me, whatever it is. I'm here to be a resource for you guys. And I guess I'll catch you guys on the next one. Have a good day.